breath, invite Andrew Woods to speak about preliminary discovery and non-party discovery. Thanks, Andrew.
Thank you, Paul. So this is chronologically, perhaps should have come first, but we all know discovery well enough to see where this fits in. This is a fairly short presentation on preliminary discovery and discovery from a non-party. So the objectives are usually to identify a potential defendant, to uncover facts to found a cause of action. They're the two areas. Now, a couple of examples from the cases I've looked at in preparing the paper. So, for example, to identify a potential defendant, it might be an example being a construction scenario where a company is invited to tender by various individuals in a coffee shop or something similar to that. They tender, they start doing some work, the site's then locked up, and the individuals want to recover their damages for both the tendering and all of the work that they've carried out, but they don't actually know who they've got a contract with. That's not unusual in construction circles, as some of you will know. So usually what will happen is the solicitors will write and say to those individuals, explain these things to us. We want to identify who it was that we had our agreement with, and there'll be silence from the other side. There'll almost always be some documents in the background that the potential plaintiffs will want to get. Another example might be a personal injury type case, perhaps an assault, a civil assault on a cruise ship. The person might have been assaulted, the potential plaintiff. They might then want to seek damages, firstly from the person who assaulted them, and they can't identify them, they don't know who it was, and secondly from the liner itself for its management of the liner. They might need some documents to find out, firstly, who was on the boat. They want to identify the person who was the perpetrator. They might want to find whether there is a cause of action against the liner itself, in that were there policies and procedures up to scratch, etc., etc. Now, there's an action for discovery down the bottom there that I've referred to. That's a common law creature. It still exists, but really this is a creature of the rules now. So what do the rules say? This is firstly to identify a potential defendant. The court may make an order where an applicant, having made reasonable inquiries, is unable to ascertain the description of a person sufficiently for the purpose of commencing a proceeding in the court against that person, in this rule called the person concerned, and B, it appears that some person has or is likely to have knowledge, facts, or that he is likely to have or has had or is likely to have had in the person's possession any document or thing tending to assist such ascertainment. So, firstly, dealing with that rule, identifying a potential defendant. So, firstly, it's where the plaintiff's unsure of the identity. The plaintiff's unsure of the identity or unaware of the identity. They are slightly different things. The plaintiff seeks an order for preliminary discovery. So there'll be an affidavit that's required where the plaintiff has to attest to the inquiries that they've made, and they've got to be shown to be and accepted to be reasonable, and that after those inquiries they still don't have a sufficient description of the defendant. The plaintiff has to demonstrate that the party against whom discovery is sought may have documents that tend to assist ascertaining the identity or description of the person sought. The relief is discretionary, but it's to be the rules are to be interpreted broadly, because they're there to provide support to existing remedies. So if it can be shown to the court that a wrong, whatever the wrong is, has been committed, and that there are likely to be documents out there, the court won't obstruct and won't get in the way of making the order. So it's the court will interpret the rules that way. So the purpose must be to enable the commencement of proceedings. So we've probably all seen circumstances where a client might have an ancillary or collateral purpose, but it's got to be shown to the court that that is the reason why the documents are being sought, and the decision can't have yet been made by the plaintiff to issue proceedings. There's some this is a federal court decision, but for all intents and purposes, the rules in the Supreme Court and the federal court are almost the same in relation to this issue. This was Allphones Retail, a fairly recent decision of Justice Foster. His Honour goes through a number of the criteria that I've just talked about, and I'll just read a couple of paragraphs of that decision. An applicant for relief must show that after having made reasonable inquiries, he or she is unable to ascertain the description of a person sufficiently for the purpose of commencing a proceeding against that person. The order plainly contemplates that the applicant needs to ascertain the identity of the relevant person in order to institute a proceeding in the court against him or her. Secondly, the applicant must show that some person has or is likely to have knowledge of facts or the possession of documents tending to assist in identifying the prospective respondent. The rule is therefore available even if relief is sought against a person who is in no way implicated in the wrongful conduct of which the applicant complains. In other words, relief is available against a mere witness or bystander, which is interesting. So you needn't think of this as only against the potential defendant. To this extent, the rule differs from the equitable bill of discovery. Thirdly, the applicant is not required to demonstrate the existence of a prima facie case against the prospective respondent. Nonetheless, the power conferred by the order is not to be used in favour of a person who intends to commence merely speculative proceedings. A material factor in the exercise of the court's discretion is the prospect of the applicant succeeding in proceedings against the person he or she wishes to sue. And fourthly, the High Court has emphasised that an applicant under a rule in the form of the order must show that the order sought is necessary in the interests of justice. That is, the applicant must show that the making of the order is necessary to provide him with an effective remedy in respect of the actionable wrong of which he complains. These observations emphasise the link between identity discovery and the applicant's complaint that he or she has suffered from an actionable wrong. So that's really restating those rules and putting some meat on the bones to explain what they mean. Now, discovery from a prospective defendant to found a cause of action, the Supreme Court rules, that's found in Rule 3205, discovery from a prospective defendant, you can read that for yourselves, but essentially it requires reasonable cause to believe that the applicant has or may have the right to obtain relief in the court from a person whose description the applicant has ascertained. Secondly, after making all reasonable inquiries, the applicant has not sufficient information. And thirdly, there's reasonable cause to believe that the person in this regard might have documents. Then the court may order, again, this is obviously discretionary relief. So there's the most recent decision I could find on the provision addressing discovery from a prospective defendant to found a cause of action was National Hearing Centre's, a decision of Justice Vickery from last year. A fairly common fact scenario when you're dealing with Order 32, which is a former employee has left employment, gone somewhere else, and the former employer is concerned that information has been taken and is being used, proprietary information. So this was a senior software programmer who ceased their employment. Prior to ceasing, there was the evidence before the court was that a particular software program had been open on the employee's computer for it might have been a 48-hour period or something like that, and the deponent in the affidavit said there was no reason why that employee should have had that particular program opened, and it was the access to the proprietary software that the employer was worried about disappearing. So really circumstantial evidence and nothing more. Which I should say will often be the case in these sorts of applications, because if you have something stronger than circumstantial evidence, then you'll probably already have your cause of action. So the plaintiff had made reasonable inquiries but did not have sufficient information to decide whether to commence proceedings, and His Honour Justice Vickery described the circumstantial of the nature of the evidence as follows. Nevertheless, standing back and looking at the evidence overall, I'm satisfied in the present case that the circumstantial evidence is sufficient for NHC who is the applicant, to have formed the necessary belief that it may be entitled to relief from the defendants and that it has reasonable grounds for having that belief. Although there is evidence the other way, such as the suggestion that it would not have been possible to transfer any sensitive information owned by NHC in the time available to the employee without first converting it into a format which would enable this to happen, I would need to hear and assess expert evidence on this issue before arriving at a concluded view on the matter. Although I take this and other evidence announced by the defendants into account, I remain of the view, and considering the facts objectively, it is reasonable for NHC to have come to the view that it may have the right to obtain relief from either of the defendants. The circumstantial evidence in this case serves to distinguish it from another case that His Honour referred to, where there was no circumstantial evidence and the discretionary relief was refused. For this reason, I'm prepared to make an order under the applicable rule, but will do so on a confined basis. So, it being discretionary, it's common that a court will say, well, I won't give you, applicant, everything you've asked for, but I will give you the right to discovery of these particular categories or documents. In that case, interestingly, I think it was access to computers and having computer experts go onto the site to look at the hard drives and see what had happened in relation to the information. Now, discovery from a non-party, this should only take a moment, is 3207. On the application of any party to a proceeding, the court may order that a person who is not a party and in respect of whom it appears that the person has or is likely to have had, etc., etc., they can make an order for discovery. Now, that's on the application of a party to a proceeding. So it doesn't quite fit as neatly with outside the and prior to the commencement of proceedings, and nor does the next point that I wanted to make. But I thought this being a fairly general discussion this morning, it should be said that we don't forget that there are subpoenas to produce. Obviously, they are available during a proceeding though as well, so they're not pre-trial. Issues. There are cost consequences of preliminary discovery that are addressed in the rules, and it will often be the case that the court will say, well, potential defendant, if you want these documents, you don't have a case against this party yet, you need to pay the costs of them coming into court, and you need to pay the costs, obviously, of that it's going to cost them to get the documents to you. Equally, it might be that if there's, and the reason for that I should say is that it might not be that any proceeding is ever commenced, so it's possible to say to the court, if you're the respondent to that application, well, those costs should be ordered now because we might not be back before you. So that's often what will happen, but the court might also, and I've seen this done a fair few times, say, well, I'll reserve the cost and we'll wait and see what comes out of that process. And lastly, there was to be, I think as most of us would know, pre-litigation requirements in the Civil Procedure Act as it was first drafted. There was to be exchange of appropriate pre-litigation correspondence and critical documents. Those provisions of the Civil Procedure Act were repealed by the new government when it came into power, so they never took effect. So the last sentence there, I think I might have, oh no, it says, so there's no power to compel pre-commencement discovery or disclosure, but you remember how broad the Civil Procedure Act is, and if there's obstructive behaviour early on where a reasonable request for documents to found a cause of action, for example, in the absence of an application to the court to get those documents, is made, and then at the end of the hearing, or when the hearing is disposed of in some other way before a hearing on the merits, it might be that you can launch a successful argument to say, well, here's the pre-trial correspondence or pre-commencement correspondence, they were being obstructive. It's totally against the grain of what the Civil Procedure Act calls for. So whilst there's no legislative requirement for pre-trial disclosure, pre-commencement disclosure, They really should have given us these things, and we wouldn't be in this position now had they have given us these documents. And certainly the Civil Procedure Act is broad enough to support costs orders in that situation. That's all I wanted to say.
Thanks very much. Thanks very much, Andrew. We've got just a couple of minutes for some questions, if you have any from the floor. I must say I'm still trying to get my head around the New South Wales procedure, Anthony, because for an old-fashioned Peruvian guano fan like myself, who's conscious that many cases were won by the Peruvian guano forensic test, and being used to going to court and having the judge more or less on side because of the interpretation of whether a document was directly or indirectly relevant, you basically got the lot and then could piece together a case from discovery. That new approach in Sydney, which is continues the evolution of discovery rules away from Peruvian guano, sounds anathema. What is it like bringing an application for discovery or disclosure where in effect you've got two opponents, the other defendant, but the judge running the commercial list on that particular day?
As I say, I think it's a little too early to get some form of consistency from the courts in terms of the way they approach this. Very often, as is our constant experience, I suppose, as litigators, it depends upon who you draw on the day. If you draw the chief judge in equity, she will give you a much harder time, I think, than maybe some of the other puisne judges will give you. From a few cases that I've observed, it really does boil down to how the courts view the question of necessity, given that it's got to be necessary in the interest of a fair trial, how the courts view the issue of necessity in the particular circumstances. Now, my suspicion is that if you get the right judge, a proper, fair-minded judge who is not overly concerned perhaps with the administrative aspects but wants to delve into the detail of the case, you will probably stand a far better chance of getting an appropriate order from that judge in circumstances than you would otherwise. So, look, a bit early to tell. It really does turn, I know we always say this as lawyers, it turns on the facts of the case, it turns upon the bench that you get on a particular day. My suspicion is if the merits are on your side, you'll be successful, regardless of these rules. But what the court, but really you need to when you make these applications, appeal to the merits of the case. Sprinkle your submissions with lots of references to necessity, lots of references to fair trial, and be able to back it up with something in the evidence or something in the pleading that makes it imperative that those documents or categories of documents be discovered early. Because the other thing that's important to do is to not overreach. Firstly, not overreaching your submissions, but also not overreaching the documents that you're seeking. If you do that, I think you've got a much better prospect of getting access, maybe to a limited number of documents, at least to enable you to prepare your evidence, which is what we're talking about here. Of course, once your evidence is on, then there are still thresholds that need to be met in terms of the practice note. That is, that you still need to file an affidavit that addresses questions of necessity, categories of documents, and cost. But I suspect when you get to that stage of the proceedings, you'll have a better chance of satisfying a court. Be my view, a better chance of satisfying the court of the documents that you particularly want, because by that stage, you will have gone through the first threshold. We would have satisfied the first threshold test, that is, the pleadings have closed, you've put on some evidence, the other side's put on some evidence, and then by that stage it should be reasonably apparent where the gaps are, it should be reasonably apparent what the real issues are, and then I think you've got a better chance of getting the orders you want than you would perhaps at the preliminary stage, where the thresholds, I think, are a lot higher than they would be a little way down the track. Does that answer your question?
Yes, it Are there any questions from the floor?
I have a question in relation to this disclosure. As I understood that even if the parties were to agree in relation to discovery or disclosure, that the court nonetheless does not take that into account and may not order disclosure. What is the consequence then if the parties do agree and in fact exchange documents? Is there a cost consequence later on because there was not a formal order?
I don't know the answer to that. I actually don't know the answer to that. The practice note only covers court-mandated, court-ordered disclosure. There's nothing stopping the parties agreeing to informal discovery. My suspicion is that if nobody makes any specific submission to the court ultimately in relation to costs or any special cost order, that'll all be taken up in the wash in terms of when an assessor comes time for an assessor to look at the costs. I imagine this, unless someone particularly raises with the assessor then the question of this wasn't mandated by the court and there should be some special consideration, then no one will avert their attention to it. Be my view.
I've just ordered that each party bear their own costs of that application. We're a bit crook where the parties have agreed to exchange documents for the court to belt them with the practice court note in that circumstance. But it's amazing what the cost pressures of litigation might prompt. Are there any other questions? If not, then I'd like to thank everybody for their attendance here this morning. Could I ask you, on behalf of to thank the three presenters we have for their presentations this morning. Thank you very much.